Back to the Lordship. Lordship, I beg to mention item number 6.
Yes. Yes,
I'm from the respondent, Lordship, respondent number 1. Lordship, if this, the state is here to file a counter, Lordship. So if Lordship may please grant 3 weeks time.
we are for the petitioner, madam, no objection. Okay. It's prayed for by Mr.
Hijumon.
Which is government advocate, then additional government, additional
No, no, Lordship, government advocate.
government advocate. How much time you want?
3 weeks time,
3
Lordship.
weeks time is granted to file counter affidavit. To which, okay, Mr.
Petitioner, madam.
You are Mr.
Jiwala.
Counsel for petitioner is also present who has no objection. Accordingly, list this matter after 3 weeks. Okay.
Obliged. Lordship, I have similar prayer for item number 10 and 11. Which is analogous matter. It's in the order list. Here, the state, I'm yet to receive instruction from the state respondent. So if Lordship may please grant 3 weeks time.
Item 10.
Item 10 and 11, Lordship. It's an analogous matter.
Okay. Mr.
Lordship.
La,
In the meantime, interim will be continued.
interim is, yeah. Okay.
Yes, Lordship.
Counsel for the state respondent. Praise for
3 weeks time,
3 weeks time to obtain instruction,
Lordship.
to which Mr.
H.H. Kinimi.
The counsel for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Interim.
In the meantime, the interim or pass address shall continue till the next returnable date. Okay.
Obliged.
May I please, Lordship?
Yes.
My lord, I beg to mention item number 2 on behalf of MD Mission Additional AG, my lord. Kindly list the matter on 29 January to
Okay. Yeah, no objection. Mr.
Hit perform.
Appearing on behalf of,
MD Mission Additional AG.
okay, additional AG. Praise for listing this matter on 29 January,
Yes.
which Miss Learned counsel for the petitioner has no objection. Stop. Accordingly, the prayer is allowed. List this matter on 29 January. Okay.
My lord, again, I beg to mention item number 3 on behalf of AIME, my lord. I'm informed that she is yet to file affidavit. So kindly list the matter after 3 weeks, ma'am. No, sir. Okay. Or my lord, affidavit is already filed. So let the matter become after 3 weeks.
You have no objection.
Yes, 1 week, Lordship. 1 week.
1 week.
Yes.
1 week.
On behalf of AIME, I'm
Okay,
mentioning
Mr. Science, similar order on behalf of Mr. AI,
AIME.
AIB. Praise for 1 week time to file affidavit. Oh, affidavit
No,
already
already
filed.
filed, already filed.
Okay. Praise for 1 week time. You're praying on for what?
AIME.
On the
To
AIB?
list the matter after 1 week. ma'am.
Okay, praise the matter may be listed after 1 week, to which Mr. Counsel for the petitioner has no objection. Stop. The prayer is allowed accordingly. List this matter after 1 week. Okay.
May I please, again, my lord, I beg to mention item number 5 on behalf of Ina Holy, my lord. Kindly allow 3 weeks time to file affidavit.
Who is for the petitioner?
I'm for the petitioner.
Okay. Mr.
Heath perform.
Appearing on behalf of
Ina Holy.
Counsel for the respondent.
Yes, state respondent.
Okay, state
Ina Holy.
respondent. Praise for 3 weeks time to file affidavit. To which Mr.
You want?
Learned counsel for the petitioner has no objection. Stop. The prayer is allowed. List is met after 3
3
weeks.
weeks.
Okay.
Lordship, there's an interim, it may continue.
In the meantime, the interim order passed earlier shall continue till the next returnable date. Okay. Till next date, huh? Okay.
Obligation.
My lord, again, I beg to mention item number 7 on
Okay.
behalf of S marriage.
Okay.
Only allowed 3 weeks time to file affidavit.
Okay. Similar order, a good name. Okay. To which Mr. So-and-so has no objection, huh? The similar order. His name shall be changed. 3 weeks to file affidavit.
Yes, my lord.
Okay.
May please Lordship.
You are also here.
Lordship, I'm for risk number 2.
Okay, Mr.
I've filed my affidavit. But Lordship, my senior's name is not reflected, so
You will file affidavit,
I've already filed.
already filed
Already filed.
for respondent number?
2.
Okay, Mr.
Oseko.
Okay, yeah, for Seco, for the appearing on behalf of respondent or of the respondent number 2, submit that he has already filed affidavit
Lordship.
on behalf of respondent number 2.
2, Lordship.
Okay, and also submits that he's senior. What is his
Lordship,
name?
my senior's name is not reflected, so if Lordship may kindly
What is his name?
Lima Wapang.
Wapang, name has
Lima
not
Wapang.
been reflected in the cause list. Stop, and praise for listing his name in there as a counsel for the respondent number 2.
2, Lordship.
The registry shall do the needful. Okay,
Like-
list is already saved, no? List is met after 3 weeks, okay.
Like my lord.
Yes,
My lord, again, I beg to mention item number 8 on behalf
Yes.
of Sabongla Chang, my lord. And my lord, I'm informed that she is yet to receive the instruction. So kindly allow 3 weeks time to file it.
Mr.
E.T. Bapong,
Okay, appearing on behalf of
Sabongla Chang,
is Subhangla Singh is
government advocate.
government advocate. Submits that the respondent need to obtain
Yet to receive. the
yet to
instruction.
receive instruction
So prayer for 3 weeks time to file it.
and prays for 3 weeks time. You have no objection, to which Miss Sangtan. Non-counsel for the petitioner has no objection. The prayer is allowed. List is matter after 3 weeks. Okay,
Much obliged.
Your Lordship, I would also like to mention item number 18.
18.
Please, Your Lordship. If it may be listed up to 3 weeks, I take the consent of the state council.
Okay, Miss
Attila Boni.
non-counsel for the petitioner on the consent of the other side. Prays for and is granted 3 weeks time. Only adjournment.
Yes,
Okay, prays for listing this matter after 3 weeks, huh? The prayer is allowed. List this matter after 3 weeks. Okay,
May I please, Lordship, may be pleased to mention item number 4. Item 4, Your
yes,
Lordship, 3 weeks may be granted for filing counter, Your Lordship.
may I please, Your Lordship, Lordship, on last occasion, this honorable court has given last chance to us that comment to values on opposition, Lordship.
Hmm.
So I pray that on the next date, Lordship, without affidavit, this matter may be taken up, Lordship. This has been filed since 2022, Lordship.
okay, Miss
Livika, Your Lordship.
government advocate. Prays for further 3 weeks time
Yes, Your Lordship.
to file affidavit on behalf of the state respondent. Stop, Miss
Mika, Lordship.
non-counsel for the petitioner submits that. The order was, this last chance has been reflected in the last order.
Yes, Lordship.
Hmm.
11/22.
Okay, submits that a last chance was given to the state respondent to file affidavit on 28,
Lordship, 28/11/22.
11/2023. as such. The state government may be directed to ensure filing the affidavit on the next, before, on or before the next date. Okay, stop. This matter after 3 weeks. In the meantime, the state respondent shall file their affidavit. Okay.
Much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, I beg the mention item number 13, Your Lordship, for hearing. Lordship, I pay that the matter be posted after 2 weeks, Your Lordship.
Before the respondent.
Lordship.
Okay. Is prayed for by the learned counsel for the petitioner. This matter after 2 weeks,
3 weeks.
3 weeks. Okay, Miss
Yes, John.
appear on behalf of the state respondent. Okay,
Lordship, I also beg the mention item number 15, 16, and 17, Your Lordship. Analogous matters, Your Lordship.
okay.
The matter can be posted after 2 weeks, Your Lordship.
You are appearing for the respondent.
Yes, I'm for the state. No objection, madam.
Okay. Mr.
And so, Your Lordship.
Learned counsel for the petitioner. Pray for adjournment of the case for
2 weeks.
2 weeks, to which the state respondent.
Yes, madam.
There's no objection. The prayer is accordingly allowed. List is matter after 3 weeks. Okay.
May I please, Your Lordship? I'd like
Yes.
to mention item number 1. I'm mentioning on behalf of Ms. Nusino for respondent number 6, Your Lordship. Kindly grant 3 weeks time to file counter.
You're
My
for-
lord, I'm appearing for behalf of Enam government. I have no objection.
Okay. Miss. Appearing on behalf of Miss Louisiana,
Lucino, respondent 6.
counsel for the respondent number 6, prays for 3 weeks' time to file counter affidavit, to which the learned counsel for the petitioner has no objection. Stop. The prayer is allowed. List is matter after 3 weeks.
Oblige, Your Lordship.
Yes.
May I please, Lordship?
Hmm.
Lordship, I beg the mention item number 12, Lordship.
Yes.
On behalf of the country for the petitioner, Dr. Paul.
Hmm.
The written document is our station, so I believe this matter will cover up to 2 weeks.
Mr.
Matter will be on the-
Medeva, appearing on behalf of Mr.
Dr. Paul.
Pong there, learned counsel for the petitioner. Some is that Mr. Pongner is out of the station
My lord, I'm appearing on behalf of S. Marin,
and
State Council.
prays for listing this matter after
2 weeks.
3 weeks, to which the learned
E.T. Papong,
Hmm.
appearing on behalf of S. Marin.
has no objection. The prayer is accordingly allowed. List is matter after 3 weeks. Okay,
Lordship, I can make the mention item number 14, Lordship.
okay.
On behalf of the country for the petitioner, PP Paul, Lordship.
Hmm.
Which we are using responsibility, so I pray that this matter will come out 2 weeks.
Mr. Medevero. Appearing on behalf of
PP Paul.
VP Paul, prays for and is granted. No, this only to list after,
2 weeks, Lordship.
okay, praise for listing this matter after 2 weeks.
There's an interim, Lordship.
Hmm. The prayer is allowed, list this matter after 2 weeks, stop. In the meantime, the interim order passed earlier shall continue till the next date. Okay.
Right, man.
Hmm.
Promotion. Item number 19 to 21.
May I please, Your Lordship?
Yes,
In this case, under certain circumstances, I have to file an IA, which is before your lordship now for your lordship kind consideration. What happened in this case, my lord, on the last day, that is on 14th, my lord, we appeared, my lord, because there were change of councils. The earlier council, was not further engaged, my lord.
you filed this IA,
Yes, ma'am. Today, I criminal 1 of 24 is before your lordship, which I find it under certain circumstances, madam. And I would like to spell out those circumstances before your lordship for the kind of consideration of this IA.
This IA one is in WPC,
Yes,
criminal number 3.
yes. That is the WPC 3.
Okay,
So this IA today, which we have filed it, and it's listed before your lordship, which your lordship is dealing with, is IA criminal 1 of 2024.
yes,
Why I have to file the IA, madam? I'm addressing your lordship to that aspect.
okay,
What prompted me to file it? That's what I would like to submit first.
okay,
On the last day, that is on 14th of December, madam, the matter came up before lordship. Then, madam, we were newly engaged, so we sought some time. Time was granted, but unfortunately, somehow, somewhere, madam, the interim order was not extended, and neither it was taken. So that's why we have to file this again, this IA under certain complex circumstances, because in the meantime, the ED with flagrant violation of the earlier stay order which your lordship and this honorable court has also granted, madam. I can show your lordship, which is also available at page 14, your lordship.
yes, by this 14.
Yes, madam. After considering all the aspects, this honorable court, my lord, on 1/6/23, my lord, I'm taking your lordship, I made the amendment also at para 3, my lord, and the main operating for your lordship is I like to read from page 16, my lord, because the submission is taken into consideration. Issue notice, lordship, page 16. my lord.
Yes,
Issue notice to the respondent returnable on 15/6/23. As Mr. Yomke Lal, Central Government Standing Council has already received notice on behalf of respondent number 1, no separate notice needs to be sent to respondent number 1. As regard to the respondent of 2 and 4, it appears that notice were received by Mr. Yomke on behalf of Y.P. Gupta, Lal, Special Counsel for Enforcement Director. Therefore, no fresh notice needs to be sent. As regard the entry claim made by the petitioner, that is all. Petitioner was saying the operation on notice dated 16/3/23 issued to the petitioner under section 8 of the PMLA Act 2002. This court proposes to hear the learned special counsel for the enforcement director also before passing any final order on the entry plan. The matter regarding the entry bill shall be heard on 15/6. Till then, when the operation of notice issued under section 8(1) dated 16/3, which is impugned in the petition, shall be kept in abeyance. So that is one aspect. The matter shall be heard again on 15/6/23. In the meanwhile, the learned central government standing council shall take necessary instruction in this regard. The learned central government standing council has no objection for keeping the operation of the impugned notice under section 8(1), section 8(1) on the PMLA Act dated 16/3 in advance till the next day. So it was kept in advance, your lordship. Then on the next day, what happened on 15, it was listed, my lord, the ED council short time, my lord, which was granted, my lord. And subsequently, the effective order was again passed on 36/23. It starts from page 19, my lord. If your lordship wants, I can read it again, but the operating part is on page 20.
yes,
It is noted that this code on 1/6 earlier, that is annexure 1, has kept a notice under section 1(8) of the PMLA Act dated 16/3/2002 in abeyance. It should be 2002. In advance, however, the interim pair for consideration on ECR is to be considered today. Heard Mr. Dinas, Salami Senior Counsel from ECR, having heard the Learned Counsel, Senior Counsel, and having developed the matters on record, the court directs that in the interim, the investigation on the ECR number such dated 12/4/22 may continue, right, your lordship? No, and no coercive action shall be taken against the petitioner. Interim order passed on 1/6 shall also continue. So by this order, it clearly sends a message, your lordship, that there is no limitation of the order. It was running and still in force as of date, because till then it has not been fixed, the period, the duration of the interim order. Then, my lord, subsequently, all the orders were my lord, till from the beginning till the last date, my lord, all the interim order were continuing from time to time. Then in the meantime, on 18/8, another order was passed. Why? Because the ED filed an interim IA minor. IA for vacation of the interim orders of 16 and 13. At 36 minor. That order was not modified, but only a liberty was given that the investigation will continue. I'll show it, Lordship, at page 23. Heard Mr. R.K.D. Chaudhary, the learned deputy SGI, and Mr. D. Das, the learned senior counsel, assisted by Mr. S. Das, for the respondent. The present application has been filed praying for vacation, modification, alteration of the orders dated 16 and 36/23 passed in WPC Criminal 3 of 2023. After hearing the learned counsel for the party, the order dated 36/23 passed by this court in WPC 323 is modified to the extent that the same order shall not be a bar for the applicant to conduct the investigation on the ECR, that is the case number of ED minor, dated 12/4/22 as per law against the respondent. Let's it again on 11/9, this case be tagged with WPC 6. So, minor, no modification alteration of the interim protection order was granted. Only liberty was granted that they were at liberty to continue the investigation. The investigation was never stayed, minor. So there is no harm in that. Then subsequently, what happened, minor? It was extended from time to time. But on 14 minor, at page 27, the relevant portion, it starts from page 24. Both the cases were tagged in, so common order was passed. On 14/12/23, at the request of the learned counsel for the petitioner, that is we might list the matter after winter vacation. So that part didn't come out, minor, whether it has been vacated or whether interim protection has been waived off or whether it has been extended. So now, because of that, minor, certain things, development has taken place we ought not to have, because the matter is sub judice before your lordship. Until and unless the finality is not arrived at, minor. So the ED cannot proceed it in view of the order dated 16 and 36. So now we are before your lordship.
But the investigation can continue.
What we want, like earlier order, if your lordship will tell you, the interim order passed from 16 and 36 shall be extended by law. And in the meantime, the hearing date will be fixed, preferably if it suits your lordship, on 31st of this month, will be before your lordship to argue the whole matter. For everything, it will be decided. And only one aspect in the meantime, what development has taken place, that on 11, that order has been passed. 11/1/24, taking advantage of the situation, madam, the ED has proceeded hurriedly, madam, in a jet speed. They have passed one order on 11/1. So that should be kept in abeyance and no effect should be given to them.
What order was passed?
Order was passed, madam, that everything is trusted upon me, madam, saying that I am connected with the case. One aspect, and second aspect, madam, they have frozen their accounts or something like that, madam. Madam,
What is that not a part of the investigation?
No, investigation they have not completed, they have not charged it.
Hmm.
And as the lordship will be aware, madam, in a case for filing a being accused in a ED case, madam, a predicted offense is necessary. So herein the predicted offense is one case from Dimapur. Dimapur, madam. In that case, madam, they have tried to show me that I am an accused in this case. For that, I have got no connection, and for that, I am also filing a quashing petition which has been registered with WPC 6 of 23. That is also pending, madam. I will be obliged, madam, if the state council will come and appear and say whether I am an accused in that case or not. If I am not an accused, then this whole case will go because there will be no predicted offenses. First. Second thing, madam, till date, the state government of Nagaland has not filed any counter affidavit to our petition saying that what role we have been played in that case. What is the connection of this petitioner on the police, Dimapur police case, madam. So this is not coming forth right now. So when the matter will be ready for hearing, madam, then everything can be taken into consideration, madam. But right now we are asking this extension of the order dated 16 and 36 and to keep in abeyance the order dated 11/1. That must be before your lordship, we are before your lordship. Because otherwise the irreparable loss will be caused to the accused.
No, no, in the meantime, what order was passed affecting you?
My lord.
In the meantime, what
In the
you are
meantime, the order is
you are
not
affected by what
from
order?
my lord.
Hmm.
They have treated me that I have committed a predicted offense as if I have.
Do you have
committed,
do you have
which
the
I
order?
have not committed.
Now, do you have the copy of that order?
That order copy. But I have given one of the income of. Oh, yeah. Because this order has attained, that order has been passed on the stay order that has already been given in view of the, has been issued under section 8(1).
Now, what is this? This
This
is order,
that order by 11(1).
order passed by?
Order passed by the adjudicating authority of the enforcement director under the PMLA Act 2002.
What the order says in brief?
That is what matter. They are saying as if they have dealt with me,
Hmm.
but the process in all before the High Court. In spite of that, they have termed me and treated me that I have committed a predicted offense. Because without any predicted offense, they cannot tag me as an accused of a PMLA case, madam. The prerequisite to make a person an accused in a PMLA case is first I have to be and committed any predicted offense. That is an offense regarding the financial aspect. So this case I have got nothing to do with. This HBJ case 1 has been registered at Dimapur and notice has been issued 8(1), and then after 8(1) this final order has been passed. But that has been stayed by the High Court on one.
This order was passed pursuant to the notice issued to you.
Thereafter. Possible that I am notified. 8(1) notice.
Pursuant to the notice issued by the authority, which was been stayed by this honorable court on 1/6, this order.
That is the notice dated 16/3/23.
Are you in any case adversely affected by this?
Yes, I am highly affected by it. Because all my bank accounts have been freezed, I am immobilized now.
Now, what is your,
Assets and freeze,
now what is your prayer here?
my prayer is that.
In the IA.
Will kindly consider that till the final hearing, which may be fixed on the 31st of this month, if it suits your lordship, the date I am suggesting. And in the meantime, as the earlier order dated 1/6 and 36 is to be extended. And the main part is that operation of this order may not be given effect, till then it may be kept in abeyance.
Now then, we have to give an opportunity to the other side.
We have
also.
filed out, they have not come today, madam. We have already served copies.
They are not present.
We have served the copies, madam. It is because we have been able to serve the copies, madam, it is already in the record, madam. So that's why we are before your lordship, madam, today. So this limited prayer, madam, for 13 till 31st. Thereafter, your lordship can take a final call. Because all the time we are having a stay order, madam. Because the High Court went for recess, madam, on that day, madam. So we could not have that order, madam. Otherwise, this order would have not been borne out.
Now, for now,
Yes, ma'am.
today we can just issue notice.
No, notice issued, madam, and in the interim that order will be back. That is my submission, because interim protection, without interim protection, I will be highly suffering, madam.
Now, is there any last date or for
Yes, madam.
execution of this?
Yes, only that.
This is a kind of order.
Yes, yes.
Where is the operative
Second
portion?
last week.
Second last. What is the operative
Well, we have just got. a-
order affecting you?
Madam, that is the ultimate end result of that order, 11(1) order is that, my lord, that it has been taken into consideration that I am committed and predicted offense in the Dimapur case number, so my property needs to be attested and my bank accounts have been frozen. Now I have become helpless for no fault of mine. My lord, since there was no extension order on the order dated 24/12, my lord. So taking advantage of that situation, my lord, this order has been passed hurriedly, my lord, to thwart the ongoing proceeding, my lord.
So the order, which was pronounced on 11/1.
Yes, yes.
So this allowed the,
Yes, they have allowed that order, my lord, but that has impacted me. If your lordship will see that they have given me an opportunity of hearing, my lord, but when we appeared for the VC hearing, the link was not given and the house did not permit us to place our side of the case, my lord. That is, your lordship will find at page 31.
page 31.
31 of the IMSS. Because all these were done in a hush hush manner, my lord. Because of the.
No, since the application was allowed on
Yes.
11/1.
Yes. Now, if your lordship will see how this order has been passed, my lord, on 31, I read the main line, my lord, bold letter. I am directed to inform you that the matter is.
Which one you are reading?
Case 31. and
31 of?
Yes,
Yeah. Yes.
I am directed to inform you that the matter is scheduled for final argument for respondent number 1 on 3/1/24 at 5:30 PM through email ID available in paper and also mentioned here. Accordingly, we opened our monitor and we said, matter, but the host, that is the PMLA authority, did not permit us. Your lordship will find at page 32 and actual 8. This is OA, this is the screenshot, madam. We have taken it being helpless. We opened it at 5:20. Since then, this was for you. OA 822 is the case number of ED and 2023 final hearing for respondent number 1, that is ourselves. Thanks for waiting. We'll start the meeting when the host joins. So we were not given the link, madam, or permission to enter into the video conferencing, madam. I have stated that in my petition also how things they have deliberately tried to derail our argument, madam. So 8-1 notice, since it was already stated by this honorable court, madam, so for taking no coercive actions, madam. So we did not file any reply, madam. So without giving a chance to file a reply, they proceeded with the matter, madam, which is was serious consequences to us, madam. We have stated everything in our argument.
But now we do not know whether it has been given effect to or not.
We
The order.
give effect, no, that's why.
Now, whether the order 11/1.
Yes, ma'am.
2024 has already been given effect to or not, we do not know.
But if we not take the stay order, madam,
Hmm.
then probably everything.
Now, what I'm saying is, we do not know whether it has
Yes.
already been given effect to or not. That is why we need.
Your lordship is absolutely
hear them.
correct. Only my interim protection for 10 days, that is till 31. Right?
So 31, why 31? 31?
No, any date, your lordship.
Okay,
I have
yes.
given my comfortable date, madam. If your lordship gives it earlier, I'll come, madam. If your lordship gives.
What other order was passed in between? Other than the order on 11/1?
Okay, this is the only last step, but.
So now, under the circumstances, as we do not know whether the order dated
Yes, madam.
11/1,
That is
2024.
why I am making a fervent submission before your lordship, my lord. The later notice be issued to them.
Okay.
Okay, no issue for that, my lord. Let them file their counter, no issue for that. Only for their limited duration, my lord, till the next date, final date of hearing, my lord. This notice impact may not be given, and the extension of the order, which has not been reflected on the order dated 14/12, may kindly be incorporated in, my lord. So that we can again take up the matter with the authority concerned. Because otherwise, if it is given effect, my lord, because by flouting all the norms, all the procedure, it is violating my fundamental rights, my lord. Right to life and liberty, my lord. I'm crippled.
Earlier,
Yes, my lord.
the order dated that those two order interim,
Yes.
since it has not been extended, now for further extension, again, we need to hear
Yes.
them, hear them also. Okay.
They have received it, the notice, if your lordship will take the head of the assistant, your lordship will find it, my lord. And the last page, definitely the notice will be there. It's a handwritten notice.
Okay, okay. Mr. Didas, Nana Senior Counsel.
I'm Zen Kumar, madam. These are for the earlier council.
Okay,
We have finally new account number, their name may be kindly be shown to be. Staff of madam.
okay, you are,
I'm Zen Kumar,
okay, Jet,
senior counsel assisted by
Senior Counsel, assisted by
J. Kali.
Khalid. Nana Counsel for the
Applicant.
applicant, huh? So still, you are appearing,
Item,
Six, I'm sorry, item,
20.
case number WBC six.
okay,
Yes.
not here,
not here.
okay.
But, Lordship, may I seek your indulgence? My learned senior friend has suggested 31st, that is a Wednesday, usually DP sits on Wednesday, whether they practically possible or not, just
No,
otherwise.
That was my suggested date. Now I have.
no one appears for the respondents, huh? Stop. The applicant filed this application for continuation of the interim order dated 1/6/2023 and 30/6/2023 passed by this court. Till the final disposal of the writ petition along with the link case. Stop. Issue notice returnable by,
But I don't know if this is.
no,
We have no concern more of this.
when is your convenient
My
date?
convenience will be of course on 31st.
31st is not,
31st.
is Wednesday, Wednesday DV. Okay. Then thereafter, February,
February.
Lordship, in that case,
No, that is for, you're in WBC six, Nadia. Now vote is taking up WBC three.
5th. Monday would be better. Okay.
Can it be on second Monday?
Hmm?
Second of February.
Second, okay. Friday, okay, second, huh? Returnable by. We'll say 2 weeks, and then in the last, we'll fix on second, okay, 2 weeks, huh? Stop.
No,
The applicant shall
take steps.
take steps upon upon all the respondents. By register post or dusty or what?
Trustee, we can,
Hand.
We can submit it.
By dusty service, huh? Within 2 days,
Within 3 days. madam,
3 days,
because
within
we have
3
to-
days from today. Stop, huh? List is matter on, is prayed for by the Lana Council for the applicant, list is matter on 2/2/2024. Stop, huh? So, interim,
Where my can be extended, madam, that's my discussion, otherwise the whole thing will become infection. And they will be taking advantage.
no,
of
because there has been intermittently, there has been,
Yes,
of
ma'am.
course,
Till
gap,
then, till
there has been a gap.
Till then, madam.
Now, you see, there has been gap, it was not extended for consecutively.
One day it was not extended.
And
somehow
no,
we-
probably prior to that also it was not
Madam,
extended.
take, note of one fact, neither it has been vacated,
Yes, of course.
so it remains vague, madam.
Yes,
So
that is,
taking
that is what,
advantage of that, madam,
that is why it need to be heard. The other side also need to be heard.
Yes, definitely.
That is
it will be
why.
hard, madam. Till then, it may be only stake, madam, for 10 days or 15 days, madam.
No, because now we do not know, as I say, that we do not know whether the order pass on, whether,
I never insists, my lord, but great harm has been done.
whether the order pass on these has
Yes,
been
my lord. 1/6 and 36, my lord.
11 was it?
11/1.
Now, we do not know what is the
My
development.
dear madam, I'm asking only one line, that not to give effect to the order dated 11/1 till the next.
No, that is why I'm saying, that is what I am saying. We do not know whether it has been already given
That's
effect
what
or
I'm
not.
saying, madam, they will give effect if they have not given effect. So this is an order which has been passed behind our back, madam. That's why I'm insisting, otherwise, your lordship, we also take what your lordship say, but in this case, it is.
You have presented this, this order also you have presented now, and we do not know whether it
Your
has.
lordship will only mention one line, I'm just suggesting, madam.
Hmm.
They're saying that till then, on the 11/1 order may not be given effect till the next, that must show, nothing beyond that. One line, madam, that will save the person, madam.
Now, you have not annexed this order as well.
No, we can.
Also.
Madam, actually, why, my prayer is there and my petition paragraph is there, madam.
No, where is
Your
the,
lordship will kindly see the para 11 of my petition, madam.
yes,
That the applicant needs to submit again receive an email from the registered adjudicating authority of the Prevention of Money Laundering Act 2002 stating that the matter is fixed for passing the final order on given to video conferencing and an order was accordingly passed and a copy of the order was sent to the applicant through email, which is before your lordship, and my prayer, your lordship will.
no, this we have not annexed.
Yes, madam.
So we had no occasion to go through
No,
that
no,
also.
but
That is
we
why.
have given there, madam. Now your lordship will see.
You should have annexed that.
Yes, madam, we will now block it, madam. Now your lordship will see my prayer at page 11, madam.
Yes.
It is further prayed that during pendency and hearing of the WPC number 3 of 23, your lordship would be pleased to keep in abeyance and not to give any effect to the final order dated 11/1/24 and all orders if any passed by the respondent tree of the editing. That must open.
No, we can prepone the date, but then you see, after,
But that.
unless we hear the other side on this, because we do not know whether it has.
Otherwise, my lord, the WPC, my lord, will hang. So we want to also bring to a
No, because-
logical conclusion, my lord.
Because we do not
We'll
know.
argue it, my lord, on 31st. Till then only I may be protected, my lord. That's my respectful submission to report it. Hence, my lord, because of the fact, my lord, great injury has been caused, harm has been caused to this repetition of my lord. Because all these things, we have not been given an audience also to place our side of the fact, my lord, our side of the story.
It will be, Lawrence Senior Counsel, it will be difficult for me, because you have also,
Only for one.
although you have made a statement in the paragraph
Yes,
7, but then
and
this,
also it-
you have not annexed, allowing this code also to go through. No, no, now,
It's there, madam. Now, law, it will be kept in the record, madam. So this is what the statements have been stated, madam.
no, this will be considered on the next stage. You may prepone, you may
Only
take
one
early
line-
date.
Only one line. I'm not asking anything, madam. I'm
No.
simply asking.
That one line is difficult.
My whole thing depends on that one line, madam.
Yeah,
My
that is right.
only thing is that.
The
till
entire case
next
will
day-
depend, because
till the next day, my lord, only, I don't ask for advance, not to
This-
give effect. Not to give effect, that's what I can say, madam. And already that 8/1 notice has been.
So many
said,
things
my
has
lord,
taken-
that this has been born out from that notice, my lord. Originated by the notice dated 16. Original dated 16/3/23 notice was issued, and this is an outcome of that notice, though it was stayed by the order dated 1.
you should have annexed it, allowing the judge,
Yes, my lord,
allowing this code also to go through.
But
What
now
is,
we have given it to your lordship.
but now how do we go through?
It's a part of the record now, my lord, since your lordship has already turned the pages and gone through the manual. Otherwise, my lord, we also will not trouble the court, my lord, but in this case, my lord, lots of foul has been played.
Retention of digital service.
Well, I'd like to add one line, my lord, for your lordship time consideration, my lord.
Just a minute, that's the retention of digital device document, records, seeds and bank accounts. Demat accounts and crypto wallet frozen.
Yes,
Hmm.
problem.
So already
No, that is
as
order.
specified in the, so how do we pass order on?
No, nothing has been stated, madam. So that's why I'm saying so, madam. When
If
the
this
next day
order-
they will appear, madam, they will say everything, madam. Then your lordship will take a final call, madam. Now, since we are. also
As specified in original application must be permitted to sit. This decision is made with regards to the investigation upholding the principle of, so this decision already made and probably taken effect. So under the circumstances, it will be difficult.
No, madam, that's why, madam, if your lordship will now appreciate one of my submission, madam, what I will submit, madam, your lordship will just bear with me for 2 minutes, madam. I'll try to satisfy your lordship. Madam, in this case, originally a notice under section 8(1) of the PMJ Act was issued on 16/3/23, madam. We challenging that notice came up before this honorable High Court.
Hmm.
High Court kept in abeyance the proceeding of further notice. That is order dated 16 and 36, madam. So we do not file our reply also because there was, since there was the stay in operation, madam, protection, interim protection order was there. So we could not file any so.
No, what we'll do is, as we do not, as this court does not know whether it has been taken effect with the interim, this, your prayer will be considered on the next date.
No, it's all there, madam.
Hmm.
Why interim orders are passed, madam?
Hmm.
Because just it's an interim order, madam. So
Yeah.
in between, nothing happens, no
Hmm.
things takes place, madam. That's why the provision of interim orders are made, madam.
No, that is why
Thereafter, madam,
you have not,
your lordship is protecting me since last 1 year, madam. Now all of a sudden, because of.
No,
the
no.
order dated 24/12, madam.
no, the,
12, madam. That order, madam, since it was neither extended, neither vacated, madam, we landed in a clean suit, madam.
you should
So
have.
that is the only problem, madam.
Hmm.
Now, that's why I am saying that this order may not be given effect till the next date, madam, and thereafter, whatever order your lordship passes, we will take it, madam.
And then you see, in paragraph 11, although
Yes.
you have stated, but then I have also marked it a question mark.
Yes.
Because you should have annexed, and then
Yes,
this
madam. That is
clearly
where now
shows,
I have
you
brought-
should appreciate the
Your
observation of the court also.
Yes, madam. Now it's not recorded before
No,
your
no.
lordship, we have placed it, madam. There cannot be. We have stated, we have not suppressed anything, madam. Your lordship has to appreciate that everything has been stated right from the beginning of the issuance of the notice till the final order, madam.
So this, according to you, is a final order. 11.1 is also final order.
Yes.
This is also final order.
Yes.
No,
Because the High Court.
no, it has already taken effect, probably. Now, if it has already taken effect, passing order, staying or not to take effect would amount to interfering. Or it will complicate. It will
Nothing
complicate.
such, my lord, I will respectfully submit, my lord.
If it has already taken effect, it will complicate.
Because of the fact, my lord,
Hmm.
this one should be under section 8(1),
Hmm.
so forth.
Hmm.
This honorable High Court in the meantime has kept in abeyance and no coercive action. Therefore, I was deprived of filing from my so cause reply. So this final order, without taking the final, my so cause reply, my lord, how can it be passed, my lord? I was at all time under the protection of this honorable High Court. Only by the order dated 24/12, my lord, that confusion has cropped in, my lord. That's why I'm submitting. Otherwise, I would have not insisted, my lord, so much too long. Till the next day, only the protection is sought for, my lord. Thereafter, they have received the notice and are not appearing, my lord, so they probably they are not in the position to give a proper reply. So that's why they might not have come. In spite of service on notice from the government. The long haul, it is a very much in a subjudice stage, by the subjudice matter.
Land Senior Council for the applicant submits that although On two subsequent occasions, probably it was not extended.
No, only one man, 14 men.
No, prior to that also, when,
That I
more,
can see
no,
too, madam.
no, on 18th.
Prior to that, madam, it was all time being extended, madam.
On 18th also, it was not extended.
But
18.8.
no, I-
18.8, although modified
Yes.
to the extent, of
Yes.
course. What we indicate.
Only for the investigation purpose, madam.
Yes, sir. So there also it was not extended. There also it was not extended.
Yes, ma'am. Only for investigation purpose. I can read it again if you want.
No, that is true.
Order dated 36 will clear the matter, madam.
Where have you stated that this, although it is not extended, but it is deemed to be continued? In which para?
Yes, but I've sent it. Para, madam. Madam, para 6, page 4. Para 6. Para 6, page 6, madam, that the applicant makes to take and submit thereafter will say WPC was listed before the Honorable High Court on various dates. And the interim protection order dated 1/6/23 and 36/23 earlier in the state WPC were continuously and consistently extended from time to time. And it was lastly listed on 14/12/23, and the Honorable Court on the request of the counsel of the petitioner applicant was pleased to adjourn the matter and further directed the matter to be listed after the winter vacation. It will be worthwhile to mention herein that the Honorable High Court by its order dated 14/12/23 has neither made any modification, alteration of the order, aforesaid order dated 1/6/23 and 36/23, nor has vacated the same. Thus, taking the same into consideration, it is evident that the interim protection order are operative in favor of the lead petitioner, and the same is still in existence and operating against the respondent number PMLA authority. In this regard, it is assuredly submitted that once the order is passed by any court of law, the same will remain effective until and unless it is vacated expressly by passing an effective order to that effect. Thus, the same interim protection orders dated 1/6 and 36 passing WC middle number 3 of 23, having not been vacated, the same still exists in this letter and speaks to all concerned. This is, I have stated the note, madam.
Mhm.
Because High Court is protecting me since the date section 8(1) notice was issued, madam.
The Lionel Senior Counsel for the applicant submit that the applicant is protected by interim order dated 30/6/2023 and 1/6, sorry, 1/6/2023 and 1/6/2023 and 30/6/2023. Which has been extended from time to time. However, on
14.
14/12, by 14/12/2023. It was not extended.
No, neither vacated,
The said order,
simply it was adjourned.
the said interim protection order dated 1/6/2023 and 30/6/2023 has not been extended nor has been vacated. Stop. We further submits that while passing the said interim order dated 1/6/2023 and 30/6/2023, it did not limit stroke fix the time period of the continuation of the interim or earlier interim order, interim order meaning thereby that the said interim order dated 1/6/2023 and 30/6/2023 is still in existence. However, taking advantage of the said interim order having not been extended on 14/12/2023, which authority?
Well, PMA, adjudicating authority, PMA.
The adjudicating authority under the Prevention of Money Laundering Act 2002 has passed a final order on 11/1/2024 through video conferencing.
Yes.
Whereby, what is the order? How do we, to summarize the order? What is the direction? Because I haven't seen that.
Order has been, documents has been seized, has been upheld,
Hmm.
and the accounts have been frozen. The operation of the account. That I give you a lot.
The operation
Madam,
whereby the operation,
madam, I will just read. I'm giving the exact paragraph. Paragraph 7.4, page 42 of the findings.
okay, which is exactly to be recorded. The current proceeding above.
Does the retention of the digital device documents records, even record, paragraph 7.5. Where it's frozen or specified as the permitted to proceed. At page 43, my lord, paragraph 7.5. The final outcome, considering the background as a presented, it is of utmost importance for seamless progression of the ongoing investigation and the fair appreciation of justice that the application submitted by the enforcement directorate is granted approval. Thus the retention-
Whereby the enforcement director, whereby the what authority this is?
Yes,
adjudicating authority has passed an order for retention of digital devices, comma, documents, stroke, records seized and bank accounts, comma, demat account and crypto wallet frozen. What is demat account?
Demat account is that, my lord, that share trading accounts, my lord.
Okay, demat
When
account
share
and,
market, we-
okay, demat account and crypto wallet frozen, comma, as specified in the original application, comma,
Must be permitted to proceed.
okay, has been permitted to proceed.
Yes. It will remain with them, my lord. I'm not asking anything. I'm only asking not to give the impact of the effect. We are not claiming anything. As of now. If we win the case, we will take everything.
So according to you, SAM has not yet been given effect to,
Yeah, madam, not given to me.
already given effect to, they have already,
No, they can't give effect, no, madam. Only because of this, final hearing, madam, we are praying for, that after that, everything can be done, madam. Now everything will remain with them. I'm not asking anything.
no, remain with them means they have already taken.
It's already taken earlier, madam.
Oh, okay,
Now, because of this protection order, they do not proceed, madam. Now on 24/12, there was no extension of the order, so they proceeded. That created hindrance, madam.
okay. The said order has not yet been given effect. Stop. Given effect to, stop.
That was.
Huh? Next step, have we fixed, already fixed? Next step, not yet, no? Okay. List this matter on to 2024. In the meantime, if, in the meantime, if the said final order has not yet, the final order dated 11/1/2024 passed by the adjudicating authority has not yet been given effect to, comma, the same shall not be given effect to till the next till the next till 2024, on which date the same shall the prayer of the applicant shall be considered, prayer including the prayer of the applicant shall be considered. Okay.
Only that 1-3 order, 1-6 order, but we will sit by the agent, because.
No, we'll say that only, this will not be given effect to.
Right.
So that extension of that will be considered on that day.
It has not died.
Your prayer will be considered on that day only. So, because.
Because if it will not given effect, my lord, it may cause hindrance, but it will never cause any difficulty to the opposite party ED, because they are well placed. We are an individual, my lord, fighting the minds of a department. So now, my lord.
No, it will automatically, after hearing the party,
Yes,
it will
ma'am.
automatically be continued.
Just permission, madam. What I'm trying to impress upon your lordship is that, my lord, this ED authority taking advantage of the gap and space created by.
Yes,
the
it could be
authority
seen,
my lord, has in a rushed out manner, tried to sabotage this ongoing petition matter. Because the matter is sub judice. They could have easily stayed also and sought a clarification there when there is no extension of stay can be proceed this and that matter. Because it has been heard and the order of equal protection was granted. Now minor case was adjourned and directed to be listed after winter vacation minor. But unfortunately, somehow the order does not speaks whether it was extended and neither it was packaged. So we are also placed in a sandwich position, but
Now, since the case has already been fixed now, probably they will also, yeah.
that's why the interim order should again come on board, minor. Otherwise, it will create more further hindrance at the subsequent stage, minor. That is my submission. Because
Next-
already the order dated 168 subsequent.
second February is not very far away. Let us wait. Let us wait.
Even then,
We'll-
I will
we'll-
be much obliged by the people.
We'll consider on that day.
Sure.
Let us.
And here's another item, madam, my madam can yes, madam.
Lordship, it may be listed on the first along with this.
My
Because-
only worry is.
Okay.
My only submission is that in this case, my lord, that whether this repetition, my lord, they have filed affidavit or not, my lord.
Whether you have had,
Lordship, we are not
Then
filing,
before
but
you
will
vote.
satisfy this honorable court when the matter is fixed.
you'll not file.
No.
Item 20.
Item 20?
Yes, Lordship, yes.
You are not filing or you will file?
No, we are not filing, Lordship, but we'll try to satisfy this honorable court when the matter is heard.
Okay.
Yes. I think order was also already recorded in one of.
Okay, that is, okay, that has already been recorded, I think,
If I'm not wrong.
in earlier order. Okay, then it's fine only.
Yes.
We want
Please.
to know whether there is anything in. Whether they can spell out.
Lordship, we'll try to satisfy this court when the matter is taken up.
Okay, that is already there, I think. Spread for by the land council for the parties. This is made along with them on second.
Right.
No? Okay.
But only thing is that, my lord, the earlier council name, my lord, he does,
Okay, maybe.
may kindly be deleted, then only the
Okay.
office will take up for.
Okay, so, in the order, huh? So Didas is no more appearing in this case. And Jamir and K Mohammed, okay. So,
And our names may kindly be shown.
okay. Land council for, okay. Mr. Central Land Senior Council, assisted by your Khalid. Samit state. Since the other advocate, Didas, senior advocate, Imkom Jamir and K Muhammad is no more appearing in this case, their name may be struck off, and instead the name of Mr. So-and-so, Land Senior Council, as you, and then who else? Jet Khalid. You file your. Oh, Wakalatnama, okay. Their name may be reflected, the petitioner shall, sorry, the registry shall do the needful to reflect the name of the councils for the petitioner in the cause list, okay.
For orders, item number 9.
Also, for the last 2, 3 occasions, petitioners has not shown their appearance. Then they are not interested with the petition.
So state also not yet filed affidavit,
No, the state is not the party.
not the party. But then says that government advocate, land government advocate for the state respondent with consent from the other side. In the last occasion, the prayer, the order says, Mr. A. Ayami, land state council appearing on behalf of Ms. Livika, land government advocate for the state. A state respondent with consent from the other side, prays for listing the matter after 2 weeks, so as to enable the state respondent to file affidavit in opposition.
I don't remember the state being met the party lordship.
No, then, how this order has come up then? Let us see, just a minute. Huh?
They have met some private respondents, party, but as far as the state, I don't.
Union. Director General, Assam Rifle, Additional Director, Lieutenant Colonel, Major General, Lieutenant, Commandant, Assam Rifle. So state probably is not a party, then
Yes,
how?
state is not the party.
then
They are
how-
not the-
Where from this order reflect that? Director General of Assam Rifle. Director. General of-
Lordship, the petitioners, they have also filed one IA for implement of the private response. Maybe it's
No, this is not in IA, this is in WPC 236 only. And probably dictated in some other order, some other,
Yes,
Yes,
they have filed an IA for implement of the private response.
it's not in IA. This order, it is clearly on WPC 236. Just a minute, huh? And in the earlier occasion, just a minute, let us see. None appears on 3010, huh? Yeah. Appearance not mentioned, return service notice. Appearance of the council not reflected. What is this matter about, by the way?
Like to, selection of,
Selection.
selection.
You are for respondent.
Yes, I'm for the Union Avenue.
Union of India, big time to file affidavit in reply to the affidavit filed by the petitioner. Hmm? No, probably.
Lordship, in the IA,
This
the
is-
IA was disposed of on 19/6/2023, including the private respondents.
This order is not in IA, but then the order, of course, little confusion. The land CJ 2 weeks time to file affidavit in reply to the additional affidavit. Okay. The order passed in IA, registry directive, okay. So in IA was filed for implement only
Implement,
probably, and then these person have been, these
The private response.
12 person have been impleted.
Yes, however, the state were not met a party.
So notice was issued to them, to the newly impleted. But still, in state is in the newly.
State is not a party. Maybe
There
wrong.
also state is not a party. It's a individual name, private person. 10 to 12. State is not. What do we do then? Because this notice step probably has taken, Return service, because 12 more person have been impleted.
Yeah.
Thereafter, the petitioner has taken steps, probably waiting for the return service report is awaited, still awaited.
Yes.
And probably that may be the reason. What do we do then? Some more time? Since. But then this order probably is dictated in some other case, because this mentioned there is a mention of state government also.
Yes, yes. I think under the wrong impression that he was also party, the state was also.
Yes,
party.
yes.
Otherwise, the state is not. a
This was
party.
on 28/11, huh? 28/11, last order. Hmm. Yangavati,
Yes, ma'am.
Mr. Yangavati, Leonard, Central Government,
Standing council.
Standing Council. CJC. Is present. None appears on behalf of the petitioner. The paragraph. The office note dated 28/6/2023 reflect that the return service report is of the step taken upon the respondent number 10 to 22 is still awaited. In view of the above, list is made after 2 weeks, 3 weeks,
3 weeks. ma'am.
3 weeks, after 3 weeks. Hmm. Yes, okay.